see. We're here from an adjourned date, March 16th. Mr. Dodge was going to cooperate and comply with mental health evaluations and recommendations and provide proof thereof. This morning, Your Honor, we received an email forwarded by Mr. Kane indicating that there is an appointment that is scheduled for April 24th, it looks like, through Northern Lake CMH. But currently, Mr. Dodge has a charge of $461 per month for one child. His balance owed is $9,890.42. And of that, $9,324.87 is owed to Ms. Kramer. Medical support to the state is $293.55. And then there are some fees and costs. Mr. Dodge was incarcerated from November of 2022 through January 19th of this year. And we're here today to monitor any kind of employment or information going forward. There hasn't been a payment on the account in the past year. The last payment was September 2021, total of $349.32 posted to the account.
Okay, thank you. So it's good to see that an appointment's been scheduled for appears to be a clinical assessment. And at this point, Mr. Kane, is your client able to work, or is he still experiencing difficulties?
He's been exercising some diligent efforts to find work, but has not been successful. I know that in our last hearing, he indicated that he was receiving a message for a potential job. Later that fell through. They ended up hiring somebody else. He has an interview later today with a fence company, which would be a good fit for a welder. So I'm hopeful for that. He was placed under the impression by me when we spoke to Barkovich today that efforts are wonderful, but rubber on the road and is what is going to matter from your perspective. You need payments. So he understands that he's got to double down on his efforts. May very well be once he starts receiving mental health treatment, it might be a little easier to employ him. So there's probably a linkage there somewhere. I would request, I guess, another 30 days. Initially, the court was inclined to adjourn this 60 days to allow him to obtain some employment and follow up on the mental health issue. The petitioner in this matter provided information to you that caused you to advance that adjournment to today. I'm asking that let's see what happens with that appointment on the 24th. Between then and now, get some kind of employment and some kind of payment into the court.
So, based on the representation of diligent efforts to find employment and also diligent efforts to schedule the appointment for the clinical assessment, I'm going to grant the request to adjourn for 30 days, and we'll come back and get an update on what the results of the clinical assessment was, and the results of continued efforts to seek employment. I mean, at some point, payments of some amount are going to have to be made. I mean, and that's the key, some amount. Anything is better than zero. Anything. And I'll just leave it at that. So otherwise, we'll be.
I am not, Your Honor.
Okay, Ms. Mullen, please call the case.
Thank you. This is the matter of Jennifer McClellan versus David Saxton, docket number 2000. Parties in the case have a third order modifying order for custody, support, and parenting time signed April 22nd, 2016, which orders Ms. McClellan to contribute child support and medical support for one child in the amount of $212 per month. Ms. McClellan failed to appear for a show cause hearing in November of 2022. A warrant was issued and she posted a reduced bond of $200 to have that warrant recalled. The balance on the account currently owed is $2,612.99, of which $2,209.68 is owed to Mr. Saxton. $104.31 is owed as a recovery to the Department of Health and Human Services. And then there are fees and costs. Oh, we lost Ms. McClellan.
All right, so we've lost our party that's been ordered to show cause. So we're going to have to we've got Ms. McClellan back, so we can go ahead and continue with the hearing. Ms. McClellan, can you hear me?
Oh, I'm sorry. This is not working too good, it seems.
All right, I can hear you now. Are you currently employed?
I was laid off. I was let go of my job the day before Thanksgiving, so in November. Since then, I have been able to obtain some part-time seasonal call-in basis work. I did submit a $140 payment for my son Friday. I do have a receipt here. I don't know that it's posted yet. to the account as of yesterday. It hadn't posted, but I do have the receipt for the money order that I mailed. And I expect to be able to send 140 again next Friday, as I have the part-time work next week as well. I have a job interview today at noon at Walmart for a more stable job. And I applied for unemployment when I was laid off and have been denied. So I've been protesting that and struggling with that and struggling myself all winter.
And okay, thank you. And we've lost Ms. McClellan's connection again. Mr. Saxton, did you want to say anything about how the lack of support is affecting your household?
Well, I believe it was December. I moved back in with my 70-year-old parents because I couldn't make my bills on my own after living on my own for 25 years. It's not all her fault. Everything is really expensive. But I also have to drive an hour and 20 minutes or so every week to pick my son back up, which means I have to buy fuel.
And I'm sure that with fuel prices where they're at, you could use the money.
I mean,
I
I
sure
pay
could.
for fuel too because I drive to pick him up too. Mr. Saxton makes more money than I do. I mean,
Well,
got a better job than I do.
Ms. McClellan, if you think that the amount of support that you're being charged is excessive, then you will need to file a motion to modify it. Those
I mean, I
forms
make
are-
$13 an hour
those-
part-time
Ms.
work, so I
McClellan,
do think that.
Those forms are available on the Friend of the Court website. This is not a hearing to modify support, though, okay? If you want to modify support, you need to file a motion. You can take a
I'm
look
just
at it.
saying I'm doing the best that I can trying to pay, what I do, and I can't even survive right now. I mean, I was laid off in November and denied unemployment all winter. And the money that I'm sending you is because I've gotten some part-time agricultural seasonal work. And I do have an interview today, but it is hard out here. And I'm struggling to make ends meet myself. And I mean, I can't pay you guys what I don't have. I just don't know what I'm supposed to do. I'm going to a food bank and commodities to feed myself right now.
All right, so the court finds that the payer, Ms. McClellan, has made a sufficient offer of proof to rebut the presumption that she has currently available resources equal to 1 month of payments. She has indicated that she's made a partial payment this month and that she will be making an additional payment next Friday. She indicated that she has an interview coming up for Walmart, so she is exercising appropriate due diligence to obtain full-time employment. She's been working part-time since being laid off in November, and she has been experiencing some difficulties because she was denied unemployment after that separation. Based on all of that, the court finds that there's no basis to hold this payer in contempt today. Therefore, the order to show cause will be dismissed.
Yep.
Thank you, Your Honor.
Morning, I'm referee Paciorka. We'll go ahead and get started. This is the date and time set for a friend of the court show cause hearing. And Mr. Schaub, I have to advise you that you have the right to request court-appointed counsel. If you make that request, we will postpone today's hearing to give you time to talk with your lawyer. And Mr. Schaub, are you requesting court-appointed counsel today?
I'm not sure what this whole thing's even about right now. So once I know what's going on, maybe I'll decide from there.
This is a hearing to determine whether or not you are in contempt of court for failure to pay child support. If you are found in contempt of court, you will be placed on a payment plan. And if you fail to make payments according to that payment plan, a bench warrant will be issued for your arrest. So because there's potential for jail time as a result of today's hearing, you do have the right to a court-appointed attorney. So with all that said, would you like a court-appointed attorney?
Well, I have a question. Did my income taxes by chance make a payment towards that? My account?
Just your state tax, sir, at this point.
How long ago was that?
That was in February.
Okay. And then what's the balance owed?
The balance currently owed, sir, is $1,834.26.
Okay. Well, I mean, I can set up a payment plan today, right?
Well, no. Right now, you're ordered to pay support each month in the full amount. The only way that you would be placed on a payment plan is if you were found in contempt of court. We haven't really conducted the hearing yet, so I don't know if you're in contempt of court.
Oh.
And if I do find you in contempt, and you go on a payment plan, then you could
Yeah.
be put in jail if you don't follow it. That's why you have the right.
Oh,
to
okay.
attorney
All
to-
right. I don't think it's necessary to get an attorney for this.
Okay.
Can I explain my story, or can I just
So
plead guilty to that?
let's
or
go
what?
ahead and have Ms. Mullen provide the details regarding the case, and then we'll hear from
Okay.
you. You can go ahead, Ms. Mullen.
Thank you. This is the
Yep.
matter of, I'm not sure if it's Kiyomi or Kimmy DuPont versus Randall Shaw, docket number 2000. Parties have a fourth order modifying order for custody, support, and parenting time signed March 8th, 2012, which orders Mr. Shaw to contribute child support and medical support for one child in the amount of $177 per month. The current balance on the account, as indicated, is $1,834.26, of which $1,771.26 is owed to Ms. DuPont. Then there are fees that are owed. Payments on the account in the past year, there was a withholding that was productive. April 2022, current plus arrearages were applied to the account. In May, the same. And then there was the last payment in June through income withholding, $105.98. And that was the last until an offset was captured in February of this year for $214.
Okay. So,
Okay.
Mr. Schaub, you can go ahead now.
Yeah. Well, I've been out of work for about a year, and I'm just trying to get my unemployment, and they kind of been jumping me around, jumping me through the hoops. But I do have an interview today, so I'll be able to be on that payment plan, and they can set it up with you guys, right? The work, or they can just withdraw it out of my account or whatever, or what?
All right. So, I guess, have you done any jobs at all in the past year? Anything?
No, I'm fighting my unemployment, and I can't get any unemployment now until they get the arrears. I haven't got paid since 2020, and they got to figure all that out first before I can get unemployment for being laid off right now.
Okay.
So it's just a big old mess, and I've been doing it for a while. But I do have an interview today, and they will be taking money out of the check. So.
All right.
I apologize for all this. I mean, it's not my intention. And they're not charging as of today, are they? They shouldn't be charging anymore as of January 30th.
Mr. Schaub, are you confident that you're going to be getting the job that you're interviewing?
Yes. Yeah. I'm pretty confident. I mean, I talked to the manager the other day, and she had me come in today, and she said she's going to go over the schedule with me. So I'm pretty confident.
What is the business?
Thirsty Fish.
Okay.
It's going to be cooking.
Okay. Here's what we'll do. Let's adjourn this to see.
Okay.
And Mr. Schaub, if you don't get that job, then
Yeah.
when we come back, you're going to need to provide some sort of proof that you looked for something else. Hopefully you'll get this one though.
Okay.
That's what we're going to be
Yeah,
looking
I'm sure I'll get it. But if I don't, I'll notify you guys right away.
Okay. So we're going to adjourn this for the reasons stated. Thank you.
Thank you.
But if it starts,
Referee Paciorka, this is the date and time set for a front of the court show cause hearing regarding child support. And Ms. Fountain, I have to advise you that you have the right to request a court-appointed attorney. If you make that request, we will postpone today's hearing to give you time to speak with your lawyer. And are you requesting a court-appointed attorney today?
No, Your Honor.
Okay, Ms. Mullen, please call the case.
Thank you. 6DM. Parties in the case have a fourth order modifying judgment of divorce signed March 24th, 2014, which orders Ms. Fountain to contribute child support and medical support for two remaining children in the amount of $174 per month. Balance on the account currently owed is $2,154.87, of which $2,091.87 is owed to Mr. Nagy. And then there are fees, excuse me. Payments on the account in the past year, there was a withholding that was productive from April 2022 through July of 2022. Current plus arrearages were paid each month. And then the last payment was August of 2022 for $104.60.
Okay. All right. Ms. Fountain, are you currently employed?
Yes, Your Honor, I am. And I just turned in, they had the wrong address for my employer, so they didn't receive the paperwork. So I have now fixed all of that with the front of the court and my employer.
Okay. And who is your employer?
Rocky North LLC.
And do we have that, Ms. Mullen?
We do, Your Honor. It looks like a withholding was generated April 15th.
And how long have you been with Rocky North LLC?
Just under a month.
Okay. All right. So what we'll do is we'll go ahead and we'll adjourn this hearing to see what happens with the order for income withholding. Ms. Fountain, in the meantime, do you have any amount that you can pay, directly at this time?
Not currently. I get paid tomorrow, so I get paid weekly. So tomorrow I get paid, and I was planning on taking a payment up to the local courthouse.
All right. How much will you be able to bring up to the courthouse tomorrow?
I'm hoping $100.
All right. So I'm going to order you to make a direct payment in the amount of $100. And when we come back, we'll see if you've made that. And we'll also see if the order for income withholding has taken effect. Speak with your lawyer. And are you requesting the order appointed counsel today?
Thank you.
Thank you.
No, sir.
All right, Ms. Mullen, please call the case.
Thank you. This is the matter of Elizabeth Kaiser versus Christopher Kaiser. This is an adjourned case from March 16th to today's date and time. Parties have a consent judgment of divorce signed November 25th, 2019, which orders Mr. Kaiser to contribute child support and medical support for 2 children in the amount of $721 per month. We had a balance for hearing this week of $2,770.06, of which $2,645.61 was owed to Ms. Kaiser. And then there were fees and medical support to the state, $82.45. However, yesterday we received a written statement from the parties indicating Mr. Kaiser had made another direct payment to Ms. Kaiser totaling $1,700. So we did apply that direct pay adjustment, which brought his balance down to $1,070.06. And so we're here essentially. Prior to that, there was a withholding payment in February of this year for $182.18. So here today, just to kind of monitorize the status of Mr. Kaiser's employment, and also to remind him that direct payments cannot continue to be made to the other party just for purposes of this enforcement and tracking of cases.
So, Mr. Kaiser, when you make a payment directly to your co-parent, if your co-parent doesn't cooperate, then it doesn't get credited for your child support obligation. So you could really get yourself in a lot of trouble doing it that way. But in this case, your co-parent cooperated, so I'll go ahead and dismiss the order to show cause. Thank you. And Mr. Ralston, are you requesting a court-appointed attorney today?
Negative.
Okay, Ms. Mullen, please call the case.
Thank you. This is the matter of Jessica Ralston, now known as Flores, versus Stephen Ralston, DM. This is an adjourned matter from March 16th to today's date and time to monitor for payments. Parties have a third order modifying judgment of divorce signed September 28th, 2022, which orders Mr. Ralston to contribute child support and medical support for 4 children in the amount of $996 per month. Excuse me. The balance on the account currently owed $16,353.37, of which $7,877.32 is currently owed to Ms. Flores in child support and medical support. There are child support arrearages owed to a former third party as well as the state. And those amounts, $4,798.58 is owed to a former third party custodian. $3,051.71 is owed in medical support to the state in arrears. And then there's a child support arrearage of $5.76. The remainder is fees and costs. Mr. Ralston made a $400 payment in March of this year, but that is the only payment made.
Okay, thank you. All right, Mr. Ralston, are you currently employed?
Yes, sir.
Okay, and are you self-employed or do you work for somebody else?
Self-employed.
Okay, and what kind of work do you do?
Interior, exterior, commercial, and residential painting.
Okay. And do you have a DBA or a business name?
I have a DBA.
Okay. And what is it's just
No, next level finishes. Sorry.
okay. All right. And how long have you been doing that kind of work for?
I started last year.
Okay.
Yeah, last year.
All right. And what did you want to say regarding the allegations that you've not been paying your child support.
Well, I was paying when I was consistently working through Taproot for the past 7 years, and then I stepped away to start a business. And things have just been going slow. It's starting to pick up now that the weather's getting nicer. That's why I paid that $400 last month. And I'm on another job right now that as soon as I finish it, I was going to start putting more money towards it. I only get paid when the jobs are done.
Okay, thank you. Ms. Flores, was there anything that you wanted to say today about how the lack of support is affecting your household?
Well, I know he's gonna say it's because he doesn't see his kids, but the kids are at the age where they don't want to see them. And if we go to court, they are at that age to choose. But I work 2 full-time jobs and go to school to support the kids. So he's gonna just keep saying that he doesn't have the money and stuff like that. And it's just getting old. Every other month we're in court and I'm just over it.
Okay. The statute that the court has to apply today is MCL 552.633. Under that statute in subsection 3, in the absence of proof to the contrary introduced by the payer, the court shall presume that the payer has currently available resources equal to 1 month of payments under the support order. 1 month of payments in this case is $996. That amount has not been paid in several months. Under subsection 1B, the court may find a payer in contempt if the court finds that the payer is in arrears, which is the case here. And if the court is satisfied that by the exercise of diligence, the payer could have the capacity to pay all or some portion of the amount due under the support order, and that the payer fails or refuses to do so. In this case, there's really been minimal to no payments made. The court is satisfied that by exercise of due diligence, that some other source of income could have been obtained that would have permitted more payments than have been made. So because of that, the court finds that Mr. Ralston is in contempt. He'll be placed on a payment plan for a period of 2 years. During that 2-year period, he'll have to pay his court-ordered child support each month, plus an additional $87 each month towards the arrearage amount owed. If he does not make payments according to that plan, a bench warrant will be issued for his arrest. The amount of the bond will be set at $500, which he will have to pay or serve 5 days in jail. This is a deferred jail sentence only. Otherwise, I believe that takes care of everything for today. Speak with your lawyer. That will conclude our hearing. Mr. Blankenship, are you requesting a court-appointed attorney today?
Nope. No, thank you.
Ms. Mullen, please call the case.
Thank you. This is the matter of Aaron Blankenship, now known as Curtis, versus Todd Blankenship. This is an adjourned matter from March of this year to today's date and time. Mr. Blankenship was to provide any medical and or social security updates. We did receive some information. And this was a case where he was having to look for a new doctor. So the information he did provide does have beneficial information, but it is from August of last year, not from a current treating physician. The parties have a 6 order modifying judgment of divorce signed May 14th, 2021, which orders Mr. Blankenship to contribute child support and medical support for 1 remaining child in the amount of $77 per month, and that charge began July of 2022. This is a first show cause hearing continuation. The current balance owed is $812, of which $770 is owed to Ms. Curtis in child support and medical support, and then there are fees, and there have been no payments on the account since the charges began.
All right, so I'll need a moment here while I review the records.
Yeah, yep, that's fine. And I just wanted to say my new doctor won't send me or fill out anything until I do a spinal x-ray or whatever. And I've got that scheduled, but so I couldn't give you the paperwork that you wanted that you sent me.
When when are you going to have this additional work done?
I have a scoliosis appointment in May. I think it's like the 20th or something, and I'm supposed to have x-rays because I got to have a specialist do it. It can't just be at the hospital, I guess. So I got to have him do it, so I'm just trying to do what you told me to. This new doctor, he wants to fill out all of his boxes before he sends you your paperwork.
So I want to adjourn this so Mr. Blankenship can get this scoliosis assessment or examination done. And then it sounds like his physician will be able to fill out that form at that point and return it to us so we can look at it.
And then also, did you see on one of the documents that I sent you that says for work, it says he will be seeking disability, and I do support him in this process.
I did see that. But like I said, we want to get the most up-to-date information, and that's the process. Sir. Okay. All right.
Yes, Your Honor.
That will conclude our hearing for today. And are you
okay, you have a wonderful
day.
Thank you for your time.
Thank you. You as well.
No, thank you.
Okay, Ms. Mullen, please call the case.
Thank you. This is the matter of Matthew Coffey versus Heidi Coffey, docket number 2009-006683 DM. This is adjourned last from March 16th to today's date and time. Mr. Coffey was to provide a copy of his most recent mortgage statement, as well as pay a lump sum of $500, which he did. And I'll provide you the copy of the mortgage statement for review. The parties have a first order modifying judgment of divorce signed December 11th, 2017, which orders Mr. Coffey to contribute child support and medical support for one child in the amount of $145 per month. The balance on the account currently owed is $806.57, of which Ms. Coffey is owed $398 in child support, and then medical support to the state is owed in the amount of $269.57. And then there are some fees. He made the $500 payment in March of this year. And prior to that, he made a payment in November of 2022 for $475. And then he made a $550 payment in June of 2022.
Okay. I had a chance to review the mortgage statement. It does indicate that he was behind on his mortgage, as he indicated at the last hearing. And he made the lump sum payment that he indicated he was going to make. So for those reasons, I'm going to dismiss the order to show cause.
He has been denied his court-ordered parenting time since approximately January 10th, 2023 and ongoing. A 21-day notice was sent to parties on January 31st, 2023. And Ms. Barber via counsel filed a response / objection on February 21st, 2023. There was notification received based on a referee recommendation order that Mr. Barkovich had to comply with some terms before parenting time could resume. Information was provided to the front of the court and Ms. Whitman by Mr. Barkovich, and then the case manager, Ms. Schimpf, confirmed with parties via letter December 22nd, 2022, that parenting time should resume consistent with the stipulated order. From what I understand, that has not occurred. And I believe it is the position that Ms. Whitman can confirm that Ms. Barber felt that there needed to be a reintroduction period because there had been a lapse of parenting time during the conditional parenting time that was entered, and that Mr. Barkovich did not submit enough evidence of compliance prior to proceeding.
Okay, thank you. All right, so Mr. Barkovich, I'm just going to go right down the list here. So first of all, as far as getting the appropriate place to live, having read Ms. Whitman's objection, it sounds like that the appropriate place to live is off the table. That's not a point of contention. Is that right, Ms. Whitman?
Yes, Your Honor. He provided a lease in December. On December 6th, he provided a copy of a lease, and we don't take issue with the fact that he complied with that portion of the order.
All right. So, Mr. Barkovich, what about the proof of continued sobriety? What would you like to say to that?
As far as the proof of continued sobriety, in your order from last July, you just said that I had to provide proof of continued sobriety. You didn't say what that was. So I started taking twice a day breathalyzers, once in the morning, once in the evening. And I've continued to do that up until this morning. On August 23rd, I believe it was, I was in the garage putting a new transmission cooler on my truck and doing a radiator repair on my truck. I heard my alarm going off on my phone to notify me to take a breathalyzer. So I grabbed the breathalyzer out of my truck, took a breathalyzer, and I failed the breathalyzer. I waited the 15 minutes required to take another test, and I failed another one. The next morning, I contacted SoberLink and explained to them what happened. And basically, they explained to me that anything from spicy food to gasoline fumes can trigger a breathalyzer, and to make sure that I am in a clear area, that my hands don't have any contaminants and stuff like that on it, to make sure that the straws that I have are clean and stuff like that. They basically said that probably what caused it was
I'm going to object as to hearsay from what Silverlink said.
This is not an evidentiary hearing, so the court will take the offer of proof for what it's worth. Mr. Barkovich, what about the September 5th?
September 5th, I was sick that day, and I provided to the court, I provided a copy of the receipt, a copy of my debit card with my debit card number that matched up to the receipt, a copy of the UPC label on the cough syrup that I bought, and the matching of the receipt. I took some cough syrup that morning that apparently contained alcohol, and I provided that evidence to the court.
I mean, the court has received the Sober Link, what purports to be Sober Link, printouts for results since September 5th. That exhibit has been forwarded to Ms. Whitman. Mr. Barkovich, how did you produce those, Sober Link printouts?
Okay, so with the Sober Link account, each day that I take breathalyzers, the next morning, I'm emailed the test results and Ms. Barber is emailed the test results. Every week, a weekly report is emailed to each of us, and every month, the monthly report is emailed to us.
Okay, and the test results since the September 5th positive, what do all those test results show?
All those test results are all passing tests. So there's like 8 months worth of passing tests.
All right. And then what about one moment. What about the requirement that you show proof of mental health treatment and compliance with such treatment by providing a letter from your treater?
Okay. Again, in your order from last July, you stated that I needed to provide a letter from my care provider and proof of such treatment. It didn't specify who, what, when, where, how, or any other requirements. The lady that I had been seeing her for 7 months after our hearing, or prior to our hearing. And there was nothing in the order stating that I had to do or change anything. So I continued to go with this lady because I had been working with her for 7 months since December of 2021.
And that lady is Dr. Lottie Hughes, is that correct?
Yeah, that is correct.
All right.
And I met her through a person on the Open Path Collective, which is a counseling website that services all of Canada and all of the United States. At the time, when I reached out for counseling back then, I was providing Melissa or Miss Barber like $2,500 to $3,000 a month, and I planned on continuing doing that. And when the guy told me how much it was going to cost, I wasn't willing to spend the $400 a month to do that.
Okay.
So
did you provide a letter from anybody else besides Dr. Lottie Hughes?
I have not provided a letter from anybody else. If Miss Barber, going into our hearing last summer, was being honest, she would have told you that prior to us signing our agreement outside of court for custody, I had just completed 2 months worth of treatment with Chad Bausemera at Munson Behavioral Health. I spoke to him and he's willing to provide a letter for me if needed. Miss Barber and I had a conversation back in January, and she knew I was taking counseling way back then. I am currently seeing somebody from the Better Help Network who specializes in cognitive behavioral therapy. She's out of Alpena. Her name's Kamara Marsh. I provided information with her LPC and proof of payments to her.
Okay. So, and so you've provided, it looks like screenshots of communications between yourself and Kamara Marsh. Is that correct?
That is correct.
Okay. And then also a screenshot of what it looks like maybe Miss Marsh's a page for her practice, which is available online. Is that correct?
That is correct. That's off the Better Help app.
Okay. And then as far as the issue of, you not going to the safe haven visits, did you want to speak to that?
As far as the safe haven visits go, I contacted them in August and I was told that they have a waiting list. I never heard anything back from anybody. I contacted them again in October and no phone call, no message was returned. And if you look in the original stuff I provided with my communication with Autumn from Safe Haven, she mentions in there multiple times that they still have a waiting list. Back in January when I contacted her, she wasn't even sure if she was going to be able to get me back then, and they were talking about moving past people up to the top of the list. And even after we did that, she said that she wasn't going to be able to accommodate my Wednesday visits. And they do a great job up there, but it sounds like they got a lot of people going through there and they're overwhelmed and they don't have enough space for it. But I did my best to try to do those visits. And again, in your order, it wasn't something that you specified was required. But I did what I could do on my end, and I was left at the mercy of what Safe Haven and their schedule was.
Okay, thank you. Ms. Whitman?
Your Honor, our objection spells out our position. Just as a global point, the reality is that Reed, who's 11, has not seen his father now for over 7 months. The intention of the order, as I read it, was that he was going to have once a week supervised Safe Haven visits pending the satisfaction of the 3 requirements. That has not happened. The testimony at the referee hearing that resulted in the July 18th, 2022 referee recommendation and order included testimony from the minor child Reed's therapist talking about how his extent of anxiety and the result of the neglect by his father being a large role in causing the extreme anxiety. The continued absence of his father, including no contact, no nothing on Christmas, nothing for his birthday, either in March. It continues that pattern. Reed did move this past fall. He's settled into his new school. He's doing really well. The concern is to go ahead and reopen the stress points with Mr. Barkovich. The reality is Ms. Barber has been willing to follow this order, but I did do a little bit of hunting on this case because it has a confusing history. And I did that this morning, and I think it's worth putting on the record that the 3 requirements are new residents with a 12-month lease and purchase. That was, in fact, he reached out to me on August 31st. With regard, on September 10th, 2022, Mr. Barkovich and I communicated via email, and I asked him for a copy of this 12-month lease that he had told me that he had as of August 31, 22. I never received a copy of it. No lease was provided until December 6th, 2022, 3 months later. During the email that he sent to me, he also sent on August 31st, 2022, this letter from his alleged counselor, Dr. Lottie Hughes. I didn't know what to make of it. It was not on any kind of letterhead. It was not actually signed. It was confusing. And we had a brief exchange then, and then fast forward to December, where December 12th, Mr. Barkovich provided the lease. And then December 22nd, the FOC letter stating that the requirements had been met was issued. There had been Safe Haven communications between the parents and Safe Haven in January, excuse me. At that point, there had been no supervised visits exercised by Mr. Barkovich since the July 18th, 2022 referee recommendation and order. There'd been it was never anticipated that there was not going to be any meaningful contact between father and son for that period. Melissa Barber, I've looked at her text with Safe Haven stating, yes, she's willing to start these visits now, but she would like to begin them as the supervised visits that Mr. Barkovich failed to exercise since there'd been such a long period of time without contact. And then I engaged in a variety of emails with Mr. Barkovich starting on February 15th, where I asked him specifically about the details regarding his treater that wrote the letter on August 31st. I asked for a release, some means of confirming treatment. I never asked for any kind of substantive information. I was simply asking for more information about this doctor. Where was she located? Did she have an address? Did she have a phone number? What was the name of the practice? What was the means of the treatment? This is a person through an email from the UK, allegedly, and I did not believe that it satisfied the criteria that any reasonable person would accept that as being proof or sufficient proof.
She's not licensed in the state of Michigan, as far as I
Nope.
can tell.
No.
Okay, look, here's my question. I mean, is there an allegation that Miss Barber has frustrated or denied the safe haven visits? That's what's not clear to me.
There was an issue in January where she didn't frustrate them. She simply wanted them to begin with the supervised visits that were supposed to start in August. And then he and I went back and forth, and he refused to provide me proof of Dr. Lottie Hughes existing, where she practiced, her contact information, his response on the 24th of February was, I've been advised not to share any info that I'm not legally required to per the order with opposing counsel. All relevant information will be addressed through the court. I had said, hey, if you voluntarily provide the information about Dr. Hughes and your mental health treatment, the matter could be resolved. And that was his response to me. Now this morning, I did receive these exhibits where it indicates he is seeing this woman named Kamara Marsh through BetterHelp in Alpena. I had no knowledge of that. He didn't communicate that to me until this morning. I still don't understand or have any understanding of whether Dr. Lottie Hughes is in fact a legitimate provider. Does she in fact practice in the UK? What's her contact information?
It's clear. I mean, okay. Dr. Lottie
He's
Hughes
never responded to me with regard to that.
Mr. Barkovich, are you asserting that Miss Barber has prevented you from doing the safe haven parenting time?
Yeah, friend of the court sent out a letter that visits would resume back to the original custody agreement on January 5th.
No, I'm talking about the safe haven parenting time that was in the order that got issued last July. I mean, I understand that it's your position that it shouldn't be happening there, but were you willing to do that while this all got sorted out? And are you saying that she prevented you from doing that?
Oh, no, I'm not saying Ms. Barber prevented me from anything. I contacted Safe Haven and they had a waiting list. And I contacted them a second time and I never heard anything back.
Okay.
So I made the effort to do the visits, but they couldn't facilitate them.
Are you still treating with Miss Marsh?
Yes, I just had a session with her on Monday.
All right. So thank you. So the court's heard enough. So the order that was issued and entered on July 18th, 2022 stated that defendant shall receive parenting time once per week at Safe Haven until such time as defendant has a new appropriate place to live, whether it be with his parents or in a new residence of his own with either a 12-month lease or evidence of a purchase, can prove continued sobriety, and can show proof of mental health treatment and compliance with such treatment by providing a letter from his treater. Once this proof is provided to Attorney Whitman and to the friend of the court caseworker, parenting time will resume as previously ordered. In this case, it's not contested that defendant has obtained the appropriate place to live. It was represented today that he provided a copy of that lease to Ms. Whitman on or about December 6th, 2022. There's an issue regarding the other two requirements. It's not disputed that defendant tested positive for alcohol on his SoberLink device on August 23rd of last year and on September 5th of last year. The court has reviewed all of the test results that were submitted by the defendant. Defendant represented that those test results are also emailed to plaintiff. So plaintiff has been in possession of those test results at all times. Those results indicate that there have been no positives since September 5th. With regard to the proof of mental health treatment, defendant provided a letter which was apparently not in a formal format by a Dr. Lottie Hughes, who is not licensed by the state of Michigan. The plaintiff is objecting on the basis that that was not the kind of proof contemplated under the order. This court finds that the mental health treatment that was contemplated in this order was treatment by a licensed therapist in the state of Michigan. So Mr. Barkovich, you're now with a licensed therapist. I looked on the state licensing database and Ms. Marsh is in fact licensed by the state of Michigan. You have provided proof of that therapy occurring. The proof, however, is not the letter that is requested by the order. The proof you provided were screenshots of communications between yourself and Ms. Marsh. So I'm just going to stop right there. the order was not followed because we don't have a letter from a licensed therapist in the state of Michigan. Okay, so that needs to be provided to the friend of the court caseworker and to Ms. Whitman, a letter from, in this case, Kamara Marsh, which says essentially that you're participating in mental health treatment and that you're complying with her recommendations. That's all the letter has to say as far as this court's concerned. As far as the alcohol issue, Mr. Barkovich is correct that the order did not really define what constitutes continued sobriety. So this court finds that continued sobriety under that order will be defined as 7 consecutive months without a positive test. Due to the ambiguity of that provision and the lack of a letter provided by a licensed state of Michigan mental health professional, this court finds that the conditions of the order that was entered last July have not been satisfied. So for that reason, the order to show cause has to be dismissed. But Mr. Barkovich, there's no reason you can't get a letter from Ms. Marsh, maybe even today. Get it out to the friend of the court, get it to Ms. Whitman. I've already ruled that as long as you continue to test negative on your sober link, that essentially at that point, you would be in compliance with all the requirements. And at that point, the order says that parenting time is to revert. I'm not modifying that. I understand the concerns that there's been no parenting time, no contact. If anybody wants to modify the order, though, they have to file a motion to modify. I'm not looking at that issue today. So I think everybody knows where this court stands. The order to show cause is dismissed, and the definition of continued sobriety will be 7 consecutive months without a positive test. That definition will be going in today's order. As far as the requirement of showing proof of mental health treatment and compliance, it has to be in the form of a letter from the treating professional who is licensed in the state of Michigan. That will also go in the order. That will conclude our hearing. Thank you.
Thank you.
This is the matter of Emily Kroll versus Mark Kroll. This is the date and time set for a front of the court motion in order to show cause the plaintiff for contempt regarding parenting time. Being at today's hearing via Zoom is the plaintiff Emily Kroll with her attorney Melissa Umulis and the defendant Mark Kroll with his attorney Jeffrey Norman. And Mr. Norman, did you wish to make an opening statement today?
Just very briefly, Your Honor. Thank you. As we're all aware, parenting time in this case is controlled by court orders. That includes the order the court entered prior to spring break here when we were here on March 21st. Fact of the matter is the plaintiff is just simply not complying with these orders. She has requested modification of these orders, but the court has not yet modified any controlling parenting time order in this case. Instead, the plaintiff has taken the law into her own hands here and quite frankly, completely hijacked Dr. Kroll's parenting time and his relationship with his daughters. So since the order reopening the front of the court case, that was back in early November, if I'm not mistaken, Dr. Kroll has been denied 26 overnights. That includes 11 nights over spring break. That was the subject of this court's March 21st, 2023 referee recommendation and order that states plaintiff shall not deny and/or interfere with defendant's spring break parenting time beginning when the minor children's class is dismissed on Wednesday, March 22, 2023 through the day before the minor children's classes resume on Monday, April 3, 2023. Your Honor, that did not happen. So the girls actually went to Florida with the plaintiff over that same period of time. So our understanding here is that the plaintiff has no intention of allowing any parenting time going forward. She's denied parenting time since the spring break period. Mark hasn't seen his girls since before spring break. Quite frankly, Judge, it's just simply unacceptable. It's counterproductive to what we're trying to do here. And it's in violation of every order entered by this court to date. That's it. That's all I have.
Ms. Umulis?
Yes, Your Honor. I guess just to start off, what's been represented regarding Ms. Kroll's interference or alleged interference with Mr. Kroll's parenting time is simply not true. The current order provides that exchanges are to take place at Safe Haven. That was pursuant to the parties' agreement in January of this year. First Safe Haven exchange took place on January 8th. My client has ensured that the children are present at all of the exchanges at Safe Haven. What has occurred is there have been cancellations on Safe Haven's end due to child refusals or due to, on one occasion, illness for which a doctor's note was provided. And it is Safe Haven's policy not to force children who are upset or dysregulated or expressing that they do not wish to go with the other parent. Their policy is to not force that exchange. I have Autumn Sletter, supervisor of Safe Haven, available to testify today. If the court wishes to hear from her, it's well documented in those Safe Haven reports, specifically in the report from the first canceled visit at Safe Haven on January 19th. Ms. Kroll's efforts to encourage the kids to go with Mr. Kroll. She has spoken positively about parenting time with him. She has encouraged them to go. She has told them that they have to go. It's documented in that report, and they have still refused. And so I guess we're at a loss for what we do at this point, because they have tried multiple different exchanges for locations for exchanges leading up to the agreement that Safe Haven would be involved. The Safe Haven exchanges, some of them were successful. It was not every Safe Haven exchange that was canceled, but on those occasions where the children expressed that they were upset, expressed that they were fearful, Safe Haven canceled the exchange. So to say that my client is in violation of an order is simply not accurate. She was compliant with the order. She ensured the children were at Safe Haven, and it's Safe Haven who has canceled the exchanges. There have been many events that have contributed to this. There's, I think, as the court knows, a very lengthy history. We have filed a motion asking to limit contact to therapeutic contact between Dr. Kroll and the children while we are awaiting the results of this custody evaluation. That is something that has been directly recommended by the children's individual counselor, Michelle Newman, who is also available to provide testimony today to the court. So my client is acting in the best interest of the children by following the recommendations of their therapist. She's been compliant with the order. And I think that the best way to move forward from here is to follow the recommendations of the mental health providers to for Dr. Kroll to participate in intensive family counseling that's already set up through Karen McCarthy. And I guess today we are asking that Ms. Kroll not be found in contempt, as she has not violated the court's orders.
So, I mean, I believe that I've seen emails from Michelle Newman indicating it's her preference that all of Dr. Kroll's parenting time occur in a therapeutic environment at the current time. Am I paraphrasing her correctly?
I believe so. I think what she recommended was intensive family therapy between Dr. Kroll and the children.
I mean, her email stated that was her preference, but I did not read anything supporting the basis for that preference. Do you have anything that explains the basis for Ms. Newman's preference?
I am able to call her to testify to that effect.
Okay, my concern is that we have 8 minutes left. So I mean,
we have
I will grant you leave to call Ms. Newman at this time, and if she can explain her position in 8 minutes and it convinces me, then I'll make a ruling. Otherwise, I'm just going to continue the current order, which, I mean, as far as I believe it indicates that the exchanges should happen at the state police post, because I'm construing the mediation agreement. If Safe Haven is unavailable, I'm construing unavailable as to be also including circumstances like this, where Safe Haven is refusing to facilitate due to the purported refusal of the children to go for parenting time. So that's where the court is on this. Right now I have Keegan Fields, Safe Haven staff, and Karen McCarthy. Will Michelle Newman be available through one of those individuals?
I'm sorry, Your Honor, she will be available at noon. She had a session and she did inform me that she was logging in at noon. I was advised that we had an hour set aside for this hearing.
I'm sorry, but that was not correct.
Mr. Norman, was that your understanding?
I advised Ms. Osborne that it would be best if this hearing were adjourned and included with the emergency hearing, because we wouldn't have time today to, do all of the things that everybody wants done.
Which was our preference as well.
So I certainly didn't indicate to Ms. Osborne that I have an hour for this hearing. I typically have at most a half hour, and today I have 6 minutes left. So due to the time constraints, I'm going to have to adjourn this show cause hearing. It will be included with the hearing on the emergency motion, which is set for hearing in May. In the meantime, the parties are ordered to follow the current order. The court is construing that to require that exchanges occur at the state police post on 14th Street for so long as Safe Haven is unwilling to facilitate the exchanges. That will be the order from today's hearing. Otherwise, I have to adjourn due to time constraints. Thank you.
Thank you, Your Honor.
Thank you.